Hello everyone, welcome back to my latest video. Today I would like to speak about an act which is very important for working people in India, particularly working women. It's called the Prevention of Sexual Harassment Act or Sexual Harassment of Women at Workplace Act 2013. Now, it is a strange topic for me to talk about given that I am a man and this one relates to women. However, I am very close to my mother and sister, and they are both working. So this is one act in which I have been quite interested in for a while. So I would like to speak about this. So So this act was passed primarily in order to protect every working woman in India from the potential of sexual harassment at their workplaces. So let's first go into how this act came about. What is the historical context of this act? So in 1992, there used to be this lady called Bhanwari Devi in Rajasthan. See, this lady in Rajasthan, child marriages used to be and probably are still pretty common, especially in villages. So the government had appointed representatives called as sathis, whose job it was in villages to educate people on the benefits of education, or more particularly to prevent child marriages from happening. So this lady, she had somehow managed to prevent a child marriage between a family called the Gujjars from taking place. The Gujjars had apparently attempted to marry off a couple of months old girl. So she had managed to prevent that, and those men had gotten angry and had raped her pretty badly. So this lady had tried to take the complaint to the authorities, but they didn't take it seriously. In rape cases, the medical examination is required to be performed within 24 hours after the incident has taken place, and they hadn't even done that. And the police were also extremely dismissive of Bhanwari Devi and didn't even take her complaint into account properly. Then when the complaint was taken to the trial court, the trial court dismissed the complaint and had acquitted all of the accused involved. With this, so what happened was this case exposed the fallacies in the legal system, particularly when it came to cases of rape and other sexual harassment stuff in the legal aspect, especially when it came to working women. Basically, in this case, even before the trial court, the police themselves did not take the complaint into account. They tried to dismiss it on charges that the medical test, the basically whatever material, biological material found on her person did not match that of the accused and all of that. They dismissed the complaint on frivolous grounds. Even the trial court and the was pretty dismissive. Later on, a couple of women's organizations in Jaipur, they protested against this callous judgment, and they took the case to the Jaipur High Court, which did pass a sentence on the accused, but the sentence was comparatively light, and the case dragged on for years and years, and by the time the judgment was finally passed, two of the accused were already dead, and they were finally acquitted. They were not punished very seriously for such a heinous offense. And later on, so again, what happened? The reason why such a thing like this could happen was because there was no specific act, no specific law for protecting women from sexual harassment and all. Earlier, during this time, they would take the case. The case was usually the legal jurisdiction for such matters was under the Indian Penal Code, Section 509. It basically talked about outraging a woman's modesty, and this and the and how a woman's our modesty was outraged was left exclusively to the whims of the police. So which means that the police with sufficient favors could be bought, and they could be influenced to not take such cases into account. So again, because there was no specific law, the authorities, they could easily choose under sufficient influence and bribery to not have to take such matter into account, which is why Bhanwari Devi's case was not given proper justice. Even today, she has never been given the justice she's deserved. She lives a somewhat dignified life. I mean, she lives the life she best she can, but it has never been completely healed because of what happened to her. So that said, that this is what the case exposed, that essentially the courts also did not take such matters seriously. So women's organizations and other organizations interested in women's rights, particularly a group called the Vishaka group, this was essentially a motley collection of several women's organizations based in Jaipur, which later on forced the judiciary to take women's cases more seriously. Now, how seriously? Let's move to the next slide and find that out. So the women's organizations in Jaipur, particularly after the Jaipur High Court's lackluster attitude to the Bhanwari Devi case, they filed a PIL, a public interest litigation in the Supreme Court against the state of Rajasthan. They called upon the Supreme Court to formulate a separate law to protect women, especially working women in India, from sexual assault and other such related cases, especially during the course of their work. So the so later on the Supreme Court, they passed a judgment around 2007, around 1997. So they declared, officially declared, sexual harassment of women as violating articles 14, 19 and 21. As in, sexual harassment, they officially declared, was in violation of the right to life, liberty and freedom under this article. Basically, sexual harassment was itself declared a constitutional offense nonetheless. So, and the another effect of this judgment, which was passed in the aftermath of the Bhanwari Devi case, was that in case where women were working at a particular place, the responsibility for their safety rested primarily on the employer. If anything happened to those women while they were working, then the employer was held primarily responsible. Unless, of course, it could be proved that the women were themselves responsible, primary responsibility rested on the employer. So this judgment, it officially recognized sexual harassment as a constitutional offense, and the Supreme Court passed down guidelines called the Vishaka guidelines, under which laid down guidelines to protect working women where they were working in their workplaces from sexual harassment at the hands of either their colleagues or superiors, or the harm or colleagues or superiors, or the employers. So these guidelines, later on, after this judgment was passed, the central government took this into account and and the legislature officially passed an act called the POSH Act, or like I said, Prevention of Sexual Harassment or Sexual Harassment of Women at Workplace Act 2013. So the 1997 Vishaka judgment was kind of the foundational basis, the foundation stone for this act that I'm talking about right now. So now that you have covered the historical basis, let's move ahead. So there is a comprehensive framework uh, for this POSH Act. So what's the framework that this POSH Act talks about? So now there are two types of business. One is organized sector. Organized sector, as in this act defines organized sector as businesses which employs at the very least 10 employees, even more than that. Basically, all the hi-fi corporate offices we see, they all are under organized sector. This act also covers the unorganized sector. They basically very small businesses, the roadside business and all we see, where one or two or three people are employed. Basically, as per the act, less than 10 employees, less than 10 people working for a business. That is comes under unorganized sector. So this act covers the safety of women across both of these sectors. So essentially, this act this act calls for preventing the harassment of women at those workplaces, and if any sort of harassment happens, this act also lays down how to redress those cases, as in how to seek redressal for such cases. So this act now this act you could say this act primarily talks about working women, but it's not just employees. Especially when it comes to organized sector, there are several classes of employees. There are the permanent employees, senior employees who have been there for a long time. There are the junior level employees who've been there for only a couple of years. There are even those who are under internship. That is, those who are there for only like a couple of months to take basic training. Then you could say they're trainees also. Then there are those who don't work there at all. They're like women who only visit such organizations for work, or then customers or clients who visit the place to conduct business with the company. This act covers all of them, not just essentially not just the people working there, or people who are working there for years, but even people who are working there for only a couple of months, or people who are under training, or even those who are visitors to that place. Not just people working there, but people who visit that place for any reason whatsoever, whether it be for business or or just casual visitors and all. And this act covers both, not just private enterprises, even public establishments like government offices and all, even they are covered under this act. So this act essentially covers all sorts of organizations, offices, government offices, private establishments, even educational institutions like schools, colleges, universities, essentially anything which can be regarded as a workplace, whether it be legally or in a general sense, any sort of workplace is covered under this act. So moving ahead, now harassment, sexual harassment. What is sexual harassment? Since this act primarily talks about that, section 2 subsection N talks about this place. So what does harassment mean? Harassment, now most of the times when we think about harassment, we usually think about the more extreme forms like rape or any physical assault on women. Now that is obvious. That is obvious harassment. But sexual harassment also includes the more subtle, you could say, let's say verbal forms of harassment. So now let's dive deep into this. What sort of harassment is covered under this? As I said, one is overt misconduct. That is, like I said earlier, if you make unwanted physical contact with women, or any sort of sexual advances, that is some sort of those sort of advances on women which they would not like. They want to just be left alone, but you repeatedly keep trying to bother them like that. So that could also come under harassment. Then if you show them, then sometimes this happens between women and employers, particularly where employers often request sexual favors from women employees in return for, let's say, if for instance they threaten women with demotion, or for removal from the organization, or entice them with promotions and all, or bonuses, or any sort of favors, that also comes under harassment. Or showing them obscene videos and pornography which they really don't want to see, or essentially material which is very explicit in such matters, sexual matters. So all of that is overt misconduct, as in obvious harassment. This sort of harassment is very obvious. There is very clear evidence of this sort of thing. That you could maintain physical evidence of this sometimes when it comes to physical assault. The wounds and bruises that are left in the aftermath of such assault, or unwanted videos or photos that are shown, there is physical evidence of this. So when cases like this are taken uh, before the suitable authority, evidence of all this can be shown. However, it is not just this obvious harassment, there is also the not so obvious but also harassment cases. Namely, what happens is, let's say if there is a woman working in the organization and you make some sort of joke or remark which is very sexual in nature, which is something which makes comments on a woman's sexuality which she obviously doesn't want to hear, but or doesn't want made at her expense, but you make it, and you make this repeatedly, that also becomes harassment. And sometimes it's not just verbal, sometimes it's non-verbal also, some sort of gestures which might seem harmless but it is really not, which really is very offensive to women in general. So all that sort of thing also comes under sexual harassment. Or like I said earlier, when it comes to employers and employees and highly unequal status, an employer requests some sort of favors from women, sexual favors in return, under threat of demotion or removal, or enticing them with promotions or high status and all, that is also harassment in a way. Now, moving ahead. Now, workplace. Till now, workplace has always meant a physical office. Like say, if one organization has multiple offices or one office, in a general sense, sexual harassment at workplace has always been meant as the place where the woman works, as in the primary place of occupation, the main office or main area of work. However, under the latest amendments, the workplace has now been amended a lot. So, how does the so what's how has the scope of workplace been expanded now? As it happens, it's not just the physical main location of office where we all typically work that has been defined under this act. Now protection for women in workplace has also now been extended to virtual workplaces. Like, let's say if you are doing work from home, and you're working via remote connection through your laptop or computer, or as in you could say Zoom calls, like you're in a video conference via Zoom call, or you're working via WhatsApp groups and all, you're passing on messages, work related messages via WhatsApp, or of course email communications. So essentially anything which is work from home, or even in offices where you are primarily communicating via email, WhatsApp, or through video conferencing like Zoom calls and all, those are also now classified as workplaces. And any sort of sexual harassment taking place via in those through those mediums also, let's say sexual remarks made via WhatsApp or email, or verbal remarks made via Zoom calls, are also now included under sexual harassment. And not just this, not just it is not necessary that sexual harassment has to cover places where you are sitting stationary. Let's say you are traveling for work related purposes from office to some place else, or you are attending a conference away from the main area of work at some other place, or you are traveling to location for work to locations where where your employer's clients are situated, or that there's also a thing where office parties are held. Corporations have this thing where they hold parties periodically for refreshment of employees or to celebrate a particular occasion. All of these are also considered as workplaces under the act, and any sort of harassment for women against women in this at this sort of places or events is also comes under the jurisdiction of this act. So essentially, in 2025, last year, the judiciary clarified that any sort of harassment that takes place not just at the main workplace but also at associated places, as in places associated with such workplace, like I said earlier, client locations or of or sites relating to such workplace where work is being held and all, that if any harassment takes place there, the act covers those sort of places as well. So now moving ahead, so what are the pillars of redressal? Now essentially what happened is, under this act, every workplace, whether when it comes to organized sector, that is the big corporate offices or any sort of office which employs at the very least 10 workers or more, it is required to constitute an internal committee. Now this internal committee, as I said, is mandatory for all organizations with 10 or more employees. And this in this internal committee, at least 50% of the members are required to be women. Now this committee usually consists of one chairperson. That chairperson has to be a woman. Then you could then two or three more members, sometimes even more, at the least two or three more members, and the half of them have to be women, since this act pertains to protecting women. So it makes sense that women have to preside over such cases. I mean, obviously, when it comes to very sensitive matters like this, same gender uh, same gender interactions are far better. Even in case when it comes to, let's say, psychiatry, usually women patients are assigned women psychiatrists and so on. Essentially, it helps. Same gender means that there is less risk of harassment being conducted in the guise of counseling or uh, any such thing. So essentially, it is obvious that internal committee 50% has to be women. Then, but what about unorganized sector? What about roads? What about informal organizations like, say, the Kinara, the shops and all, which where very few are employed, like minuscule, like at the most two or three people, or sometimes only one person is only two people, like say the proprietor and some helper is kept if she is a woman. These are very informal sectors. Obviously, organizing their own committees doesn't really work in such scenarios, since they don't really have enough people for that. So what sort of committee that covers such sort of small organizations, informal ones? As it happens, every the state government has to appoint a particular district magistrate. That is, let's say over there in that district, there is basically, if there's a particular organization is located in a district and it's very small, and some sexual harassment case takes place. Now obviously there is no internal committee there. Since it's very small, they don't have people for such a committee. So where can such woman file a case with? As it happens, this act lays down that the state government of that state, it has to appoint a particular district magistrate as a local committee. That district magistrate, he has to constitute a local committee there. That district magistrate, he has to become the chairperson of such local committee. Essentially, the state government for that district has to constitute a local committee and appoint a district magistrate of that area as the presiding officer of such committee, and a couple of members too. Okay, well, let me amend this. My mistake. A local committee is not really constituted by the state government. I mean, the state government gives the orders and all, but it has to be constituted by the district officer. Every district in a particular state has to have a local committee where the officer in charge of that district, usually a district magistrate, like I said earlier, has to constitute such local committee with himself as the chairperson and along with 2 or 3 more members, usually members who have had experience in social work relating to women's rights and all. Then this committee has to take charge of cases filed against employers coming under the unorganized sector. So local committees for this sort of firms. Now moving ahead. So now what is the step? There are now let's say a sexual harassment case has happened against a woman at a workplace. So obviously she wants to file a complaint. Now how does she go about it? One, if for instance, if it is an organized sector and let's say if it is a big company, obviously they'll have their own internal committee. So the woman has to take up the case before the internal committee of that company in charge of sexual harassment cases, and she has to submit a complaint before such presiding officer, and she has to do it within 3 months of such incident. That said, it is not just her. If for instance she is unable to file the complaint, if she is too traumatized by the incident to be able to file a complaint, it happens if sexual harassment cases are so severe, then it can be done either by her family members, her immediate family members or extended family, whoever is interested in her, by even her co-workers who who take an interest in her welfare, who are concerned for her. Even they can do it on her behalf. The woman doesn't have to do it herself. Essentially, if the woman herself is best placed to do it, but if she can't do it for any reason, anybody on her behalf, her co-workers or her family members, they can file the complaint on her behalf. Then for some reason, let's say if the woman decides that she doesn't want to make a fuss of it, she wants to settle the matter quickly, so or she can seek a conciliation before the inquiry starts against against the offending party. In this, however, if such conciliation happens, there is no monetary settlement. The aggrieved part, the defaulting party is not allowed to simply settle the matter by paying money. He has to perhaps do something for that woman in kind, or do a, like say, a written apology, or no, more than that, do something for that woman, something apart from paying her money, which will redeem the offense against her. Now of course this is optional. Most of the times at the sexual harassment case against women, it is a very serious matter, a pretty horrible matter. So women most of the times should not, or and rather will not seek such conciliation. So obviously they will choose to not only file a complaint but allow the inquiry to happen, because that's the only way a woman could get her grievance redressed. So let's say in the majority of the cases, like I said, if conciliation is not sought, then the internal committee, in case of organized sector, or or local committee, in case if it is a kirana shop or unorganized sector company with with less than 10, so they will institute an inquiry, a sort of quasi-judicial inquiry, as in the internal committee and the local committee, they have both been bestowed the powers of a civil court, or even to some extent even criminal court as well. They have the power to summon witnesses, take their testimony, take into account to admit evidence submitted in relation to such harassment case, decide the case on the basis of witness testimony and the representations made by both parties, and the overall evidence submitted to them. Essentially, both the committees function like a court. Put it this way, this act is kind of a special act where both these committees have been bestowed the powers of a court. The official courts like district courts or the high court and all, they are not allowed, they cannot entertain any sexual harassment cases relating to incidents at workplaces under this act. the internal committee and the local committee have to take charge of such cases. That said, you could appeal to the Supreme Court, since the Supreme Court still remains the ultimate authority, but that's pretty rare. You just like both of these authorities are pretty much the sole quasi-judicial authorities when it comes to deciding sexual harassment cases. The official courts do not come in the picture, and they can hold an inquiry just like a normal court hearing, following the principles of natural justice. Like I said earlier, they have to hear both the parties, take into account all evidence submitted, uh, all the testimonies of the witnesses and all. Now ahead. That said, such inquiries cannot be held indefinitely. Sexual harassment cases are very sensitive cases which are best resolved as quickly as possible. So, yeah, a woman or anybody on her behalf, like I said, whether it be her co-workers or family members, they should file a written complaint, not an oral one, a written complaint as proof that a complaint has been written. Written records are always best in the legal aspect. So they have to submit a written complaint within 3 months of the incident that took place. Or let's say if sexual harassment has been occurring continuously, like remarks are being made against that woman over a period of time, or the woman is being harassed over a couple of months, or sometimes even years, God forbid, then 3 months from the last incident, like a series of incidents, and the last time the such incident took place, right from the last time such incident took place, within 3 months of that, the complaint has to be filed. Then once the complaint is filed and the inquiry is instituted by the committee, either the internal committee or the local one, they have to complete that inquiry within the 90 days, aka 3 months, not aka, within 90 days. That is, let's say 3 months after the complaint is filed. They have to do this. Then once the inquiry is made, and once it is done within 90 days, the committee has to prepare a report stating its findings and course of action to be taken by the employer, and it has to submit such report to the employer uh, within 10 days of the report completion. Once the report is made within 10 days, they have to send it to the employer, offending employer, or the employer within whose place the offense took place. Then once the report is made, the employer is obliged to implement the recommendations made in the report within 60 days. Once they receive the report, within 60 days or 2 months, let's say 2 months, the employer uh, has to make recompense to the aggrieved woman in accordance with whatever has been stated in the report within that period. Of course, there is also provision for appeal. That is, let's say if the woman is not happy with the report, uh, uh, I mean, the woman is also entitled to such report, not just the employer. A copy of such report should also be submitted to the complainant, whether it be the woman herself or any of her relatives or co-workers. And if they are not happy with whatever has been said in the report, they can file an appeal within 90 days from the time such report has been received. So again, now as I said earlier, the since the regular courts are not allowed to take charge of such sexual harassment cases, the specific bodies have been constituted under this act. Namely, in case of big companies and medium-sized companies with 10 employees or more, they have an internal committee. And in case of unorganized enterprises or small enterprises, really, like say proprietorships or kirana dukanas and all, which operate which have very few employees, like minuscule amount, 1 2 3, less than 10 to be precise, they have a local committee. Both of these committees, they operate as a quasi judicial bodies. They have been bestowed the full powers of the core of regular courts. They can function as regular courts do. They essentially they function as a sort of civil court. They have full authority to summon both parties for hearing, to hear their representations, to summon witnesses and record their testimonies, to take into account evidence and decide the and give an ultimate judgment or report on the basis of the witness testimonies and evidence collected and representations and all. So and the one advantage is this sort of sexual harassment. These cases are you could say they can be they have very strict this committees. They have a policy of strict confidentiality, as in it is required that both the parties be heard in strict confidence, that the proceedings happening in such cases be not made public. In fact, the RT Act, the Right to Information Act, where people are usually required to be given any information they ask for, does not cover sexual harassment cases under this act. If someone files an application for getting information pertaining to an ongoing sexual harassment case, or even a case which is long over, they are they are obliged to not be given such information, as in there is an obligation that they not be given this sort of information. It is an off essentially, if someone does obtain this sort of information through any means, he or she is liable to very strict punishment under this act. So even the RTI Act does not cover this sort of case. Essentially, this sort of very sensitive cases are heard under strict confidentiality. This strict confidentiality is presumably to protect the woman's modesty and to protect the woman, the aggrieved woman, from any further harassment, whether it be at the hands of the defaulting party or anybody associated with such party. So this way complainants are protected from any sort of retaliation should if the matter were to go public. And not only that, because the woman in such cases is very traumatized. Sometimes what in this act there is even a case, there is even a provision which says that if a woman is highly often traumatized by such incident, or sometimes even series of incidents, the company where she works, or the firm where she works, is obliged to provide her leave from work for at least 3 months, and that is including any leave she is officially entitled to at the company. So she is entitled to take leave from work in case of such harassment cases, and in such sort of cases, the defaulting party is not allowed to cross-examine such woman, such traumatized one. This way, the woman is protected from unnecessary, from her mental health being deteriorated any further by her trauma being aggravated. That said, even in such sort of that said, any false sexual harassment cases, if they are filed and if the committee finds out that such sexual harassment never took place, that it's a false case, then the woman or anybody who filed the complaint on her behalf is likely to be punished just as harshly as the respondent would have been had the case actually happened and had he actually been guilty of such case. So it is advisable that the cases filed in such act be genuine, that the woman in case be genuinely offended, that it should not be a case of opportunism or vindictive revenge, where she files the case against the respondent just because she has a grudge against him, but he hasn't really done anything against her. That sort of frivolous case filing is not allowed under the act. The committee, if it finds out, is liable to punish the woman just as harshly as it would punish the respondent party were he to actually be guilty. So one should be very careful while trying to use this act. That's all. Then in high level case, then when it comes to very high level cases, so let's say So last year in 2025, there have been some judicial rulings. There was this case in Delhi High Court called XV Academy and others, which judgment was passed in August 2025. So what happened, let's say if a complaint was filed against one person, not and this one person qualified as an employer by himself, that he wasn't just some superior or fellow colleague in an organization, but literally a person who was an employer. Well, this mostly happens in case of proprietorships, where it is a enterprise run only by one person. So in such cases, an individual does he is an employer in his own right. So obviously in proprietorships, in case of proprietorships, even if internal committee is usually not constituted because proprietorships are usually small, but even if they are pretty large, let's say 10 employees or more, then well, sometimes the internal committee constituted could be heavily rigged in favor of the employer. That even if the internal committee is heard, it could be heavily influenced by the offending employer to act in his favor. So even if a woman is files a case against the employer in such committee, she is unlikely to get justice there because the employer will rig the case in his favor. So a judgment was passed stating that in such cases, the woman should take the case not before the internal committee but before the local committee. That is the committee officially established by the district officer in charge of the district. Since such district officer is likely to be unbiased in favor of such employer. He is likely to judge the case more fairly. The such committee will judge the case more fairly. So obviously, so in such cases, the local committee has to decide such cases, not the internal one. So now moving ahead. So what happens? Let's say if an inquiry has been made and after the inquiry, a report has been passed on to the offending employer or employer within whose premises the offense has taken place, and he or she or it, if it is a company, is asked to implement those recommendations. Now, what happens if those recommendations are not implemented, especially within the 60 days period that I talked about earlier? So the penalties are very severe. Number one, if the employer does not constitute an internal committee, despite having 10 or more employees, despite it being a moderately sized company or even a big one, if they don't have an internal committee of their own dedicated to sexual harassment cases, or if they don't implement the recommendations like I said earlier, there is a heavy penalty which extends up to rupees 50,000, and this is only for the first time. For a first time this happens, if they don't constitute an internal committee or they don't implement the committee's recommendations at all, and this happens for the first time, a heavy fine of max 50,000 is imposed. However, what happens if if such sort of offense, if such sort of failure to implement recommendations or constitute IC, if this sort of offense carries on repeatedly? Recidivism, to use the legal term, is where offenses happen again and again despite punishment being imposed the first time. So obviously repeat offenses are punished far more severely than first time, because it means that the offender has not learned from his previous offense. So obviously in case of repeat offenses, the penalty will be far more severe. Let's say if the business offending business is operating under a license, that license could get cancelled, or if it was registered with a particular body and such registration was essential for it to carry on business, that registration could be cancelled. So all of these are very severe offenses, which means a business could essentially be shut down or rendered illegal just for repeated non-compliance. So essentially, non-compliance under this act is very heavily punished, especially in case of repeat offenses. So it's best to comply with this act. to put it succinctly, to summarize it. Then last year under 2025 rules, there was this especially when it comes to companies, they mandated the board of such companies, the board of directors or any board in such company to periodically submit a report where they need to state how many sexual harassment cases were filed, how many were resolved, how many are still pending with the internal committees and all. This is to ensure that sexual harassment cases are taken seriously by the said company, that women are well protected in such workplaces. Obviously, women are an important part of the population, so their welfare matters, especially when they are employed. The 50% of the population, if it is kept down, if their welfare is not looked after, if they are not looked after at all, their productivity could go down. It could disturb the balance in the company, or it could affect the operations of the company. That's why and also on a moral from a moral standpoint, taking care of women is important, since women are an important part of our society. So implementing this act is important for all companies, which is why to ensure that companies don't slack in implementing this act, they are required to submit periodic reports to the authorities stating regarding such cases. So move ahead. Now, now obviously filing physical complaints can be a hassle, and it may not have proper confidentiality. Sometimes a woman is so traumatized that she stays at home and she cannot bring herself to travel all the way to file a complaint. Sometimes the offending party, they could hire people to threaten the woman with severe consequences if she tries to seek justice. As it happens like this, essentially extortion or coercion, all of this plays a role in physical compliance and physical seeking justice. So the Ministry of Child and Welfare Development by the central government, they have made a website called the She Box, that is Sexual Harassment Electronic Box. It is a dedicated website for filing sexual harassment cases in the workplace. So all you have to do is go to this site. There is a link called file and register a complaint. You can in cases of physical filing complaints physically, the problem is the information regarding such complaint, it could trickle back to the offending party, which could who could in turn retaliate by threatening the aggrieved woman with consequences, or threatening the lives of her family and all such severe consequences. So in order to prevent all of that, this dedicated website has been made where the aggrieved woman herself or her family members and all, they could file a complaint sitting in the comfort of their homes or anywhere else anonymously. That it need not be traced back to them until the time the inquiry is instituted. So once the complaint is filled out in this website, this complaint automatically goes to the relevant internal or local committee where the woman is either working, in case of internal committee where the workplace where the woman is working, or in case of local committee where the woman resides or works, where the offense has taken place. This complaint online is automatically forwarded to such IC or LC, and they can take into account and decide. Not only that, once the complaint is filed online, there is you could the aggrieved woman could even track the complaint online. Once the complaint is filed, she could check the status of the complaint by tracking it online. There's a special button where it's called track your complaints, where you could track it online, where you could find out how the progress of the complaint. When the complaint has been filed, how long has it taken for the relevant committee to take it up, when the inquiry is going to happen and all. It could give the woman sufficient time to prepare herself for the ordeal ahead, for the legal ordeal ahead and all. So yes, so our real-time tracking, not just tracking as in past tracking, real-time tracking, live tracking, just like how we see cricket matches and all live on TV. This is also real-time tracking, that when the complaint is filed, where at what time the committee is taking on the complaint, at what time the inquiry is happening, at the decisions being made, all of it is the progress of all of it can be shown real time to the complainant. So, so that way the woman doesn't have to take the trouble to visit an office repeatedly to find out how the complaint has gone. All she has to do is go to the website, find, switch or click on track your complaint and find and enter the number of the complaint, whatever the acknowledgement number of that is usually received on online filing, and check the status. That way she doesn't have to trouble herself to visit an office. So it's very convenient. And and physical visit has its problems, like the if the offending party is keeping a track on the victim's movements, and if he finds out where she's going, he could harass her on the way or threaten her, sending her threatening emails or messages, or just hire some people to threaten her while she's on the way to the office and all of that can be prevented by means of this website, by means of the facilities provided on this website. So ever since this website has been made for the purpose of sexual harassment complaints, this website has been used very well now. In August 2024, this website was renovated, revamped, so to speak, partially. So a total of 296 total cases have been filed with the use of this website. So electronic filing of sexual harassment complaints is also a very important feature, a recent one, and one which it is advisable to use by all women, as in the aggrieved women. It's best to try not to give the offending party any evidence of, and basically it's best not to give the offending party any proof of what you plan to do against him. Physically going to the office or physically filing complaints means it amounts to an evidence trail which the offending party could find out by any means necessary, by any means which he thinks is necessary. So electronic filing, especially the anonymity feature that this website provides, is far better. So my advice is to you, or to those to aggrieved women, is use this SheBox website to file your complaints. Try not to visit an office as best as you can. Then in recent eras, the corporate governance, especially when it comes to the sexual harassment cases, the guidelines have become even more stricter. Supreme Court has been giving out new and more mandates under this act, and the mandates under this act, they are moving. And not only that, under this act there have been stricter rules that have been passed mandating the board of such companies to disclose sexual harassment cases more accurately to authorities under this act. So all of that has been made more stricter in order to ensure better redressal of women's complaints, to ensure better justice to women. So what happened was, in 2025, the Supreme Court mandated a nationwide survey, as in it made compulsory that all over the country a survey has to be carried out across all the districts of all states in the country to verify the status of internal committees of companies, that is organized sector, to find out whether how well those internal committees have been constituted, what is their composition, is the composition proper as per the requirement of the act, whether complaints are being filed properly by the with the committee? Is the committee taking proper measures to resolve such cases? How the cases are being resolved and all? Is it being done well? All of that the survey has to carry out. The Supreme Court mandated it. So from July 14, 2025 onwards, it has been mandated that whatever reports are prepared and passed on to the authorities by the board of such companies, first of all, when it comes to when it comes to the composition of such board and even the internal committees of such companies relating to sexual harassment, one thing it has to be disclosed is the gender composition. Sometimes it is possible they could cheat by simply putting men in charge of sexual harassment case. Obviously, if it is men, if the offending party happens to be a man, it usually is, the judgment could be biased in favor of the men. The women would be denied justice. So obviously, the board reports have to disclose whether the proper composition of women in such committee is there or not presently. If the requirements of the act are being implemented or not. And of course, how many sexual harassment cases have been filed, how well are they being resolved, how many have been resolved, more importantly, how many are still pending, and how soon can they be resolved. All of that has to be disclosed. This way the act can be better implemented. That way it ensures that the offending men, they don't get away with their crimes, and the companies, they take such sort of sexual harassment cases more seriously, and that their women employees who are the victims, they get better justice and all. And essentially, if the companies do all of this, in the long run it helps them also. After all, women are being highly empowered today. The age when women were simply meant to stay at home and be housewives, it's long past. Women are playing a disproportionately high role in the workplace, and many women employees, they make better workers than men. It is a very common fact. So obviously, if women's welfare is affected, their productivity gets affected, and the company itself could run into heavy losses in the long run. So looking after the welfare of their women employees is in the company's interest too, ultimately, in the long run. So it is better if the company takes sexual harassment cases more seriously, and files all of this case, and resolves such cases speedily and in a proper manner, more fairly. So that's that. Then with these stricter guidelines, especially when it comes to the big Indian companies like Tata, Mahindra and Mahindra and all, as well, let's say the big Indian companies. So these companies, they saw a 6.2% rise in reported cases in financial year 25, 26 or 24, 25. So what happens is, because of so this apparently signals that the system of redressing sexual harassment established under the act, especially in the case of online sexual harassment, that is now being trusted more and more. Of course, not all cases are reported. Sometimes the women and all, they are being sometimes they don't report cases at all out of fear of retaliation. So there are still deficiencies in the system. Those deficiencies are being slowly addressed, but it will take time. The system is not perfect. There are sometimes, if the offending party is very powerful, and there is a real threat that such cases, if reported, means even more harm to the woman or her family or friends. So such cases often go unreported even now. So the system needs to be improved even more. It needs to be uh, improved even further. Of course, like I said, I should also state here that it's sometimes women are not necessarily just put in home, not at home. Sometimes our co-workers may not be interested, or even our family might take sides against us. So such women, if sexually harassed, is often put into care. Like there are specific institutions where victims of sexual harassment and all, they are uh, put there for a specific period of time. They are cared for by certified carers and helpers. The basically the staff of such organizations. So sexual harassment complaints can also be filed by such carers and helpers. That is, wherever whatever institution those women are in, the people in charge of such institutions are also empowered to file sexual harassment cases. I should have mentioned that as well. So essentially, co-workers who are interested in her welfare, her family members, or if she is in care, the institution where she has been put for care, the people in charge of those institutions, her helpers, carers, even they can file sexual harassment cases before internal committee or local committee. So that's that. So let so when it so this so to come to a conclusion, under this act provides for protection of women against sexual harassment. So women, those of you who have been the victims of sexual harassment and all, I won't specify since this is a very sensitive matter. So this act is it is your shield. It is your protection against sexual harassment in any matter. So I hope this video has helped you to become more aware of what you can do if some man or some very powerful fellow is consistently harassing you or has harassed you very badly in the past. So use this act, file your complaint, get an inquiry done, or if you can't file a physical complaint, use the she-box site to file your complaint, track the status, ensure that your rights are looked after, that your rights are protected. As a woman is equal to a man. Both woman and man are required for a society to function well. So a woman's welfare is very important. So use this act to protect yourself. Don't just sit quiet and take your harassment lying down. File a ensure you get legal justice for whatever you have endured. Not and also, if this act is implemented properly, if you take action against whoever is harassing you in the workplace, so more women might follow suit after you. They would get inspired by our action, and you could ensure as a safer harassment free workplace. Essentially, nowadays it is impossible to keep women out of jobs. The age when women were mere housewives is now over. Women are employed increasingly in workplaces all over the world, and it is proven that they make far better workers than men. So ensuring welfare of women at workplaces is very important, not just from a moral standpoint, but also from a practical and productivity and financial standpoint. If women are taken care of, they will be enticed to work harder for the company. They will be enticed to be more productive, and the company would benefit from such productivity. Their profits would increase. Such companies would flourish in the long run. By contrast, companies where women employees are consistently harassed and no steps are taken to redress such harassment, the woman would not be enticed to work properly. And if a very talented woman employee is lost because of failure to act on her behalf, then the company would end up losing a lot in terms of what productivity she could give to such company. So it is important for companies also to look after such women employees, not only from moral standpoint, but also from practical and financial standpoint. So this act is very important, especially for when it comes to harassment of women at workplace. So the implementation of this act has to be done properly. All companies, all workplaces have to implement this act well. They should do better. They should essentially try to do well by their women employees. That's all I mean to say. So I hope this video those of you viewers who are women who are at workplace, I hope this video enlightens you to take any measures should any harassment happen against you, or those of you who have suffered harassment, I hope this video helps you all to take the necessary action to seek justice, to seek any sort of justice. Don't take injustice lying down. Uh, Take action. Taking action is the only way you could attain some sort of peace. You could ensure your own welfare better. Essentially, we all the only people, essentially people will take an interest in your welfare or only when you take an interest in it yourself. If you take action, others will be inspired to follow. The others will be inspired to help you. As they say, God helps those who help themselves. So if you do your best to help yourself, or if you have the strength to help yourself, others will follow suit as well. Others will also be inspired to help you. So help yourself, use this act to your own benefit. Once again, I hope this video helps those of you who have suffered, or those of you who are not suffered. I hope this video acts as a good source of information. I thank you all for watching this video. Please subscribe to my channel at Siddharth Bhatt 4898 for more of my videos. And for the videos that I made earlier, please do watch them. And I hope this video and those videos also help you all for to get whatever information you want. Again, for that, subscribe to my channel at Siddharth Bhatt 4898. I thank you all for watching this video. Thank you. Thank you all. Thanks.